Hello and welcome back. In the previous video, we talked in terms of Frederick Douglass's speech and how he had hope and how similar it was to Thurgood Marshall's African American perspective of the Constitution. In today's video, we're talking in terms of a dissent. So, Justice Harlan, the only Southerner on the Supreme Court at the time, who was a slaveholder, and his father was a slaveholder, and he benefited from, and he saw the brutality of, the Klan's terrorism against the freemen post the Civil War. When he was elected to Attorney General of Kentucky, he's appointed to the Supreme Court. And in the Supreme Court, the case of Plessy versus Ferguson comes in. Plessy is the case that talks in terms of separate but equal. And the years 1865 to roughly 1875, you had the post-Civil War, and you had, as Thurgood Marshall said, the nation survived, but the Constitution didn't. You have these new Civil War amendments, the 13th, 14th, and 15th Amendment, which gives citizenship, equal citizenship, to the ex-slaves. And so Plessy versus Ferguson rules that it's okay to have public facilities as long as they're equal but separate according to race. So Harlan writes a dissent, and the dissent, as I said, has no legal bearing. It is a marker or a flag of a justice who's putting down for hopefully future generations, future judges, to pick up the argument and hopefully one day get a majority of the court to agree to it. Justice Harlan was the lone dissenter. And as the authors put it, in his classic ringing dissent was quoted by Thurgood Marshall in the battle to desegregate the schools in the 1950s. Harlan insisted that the U.S. Constitution was colorblind, a view that remained at the heart of the 1990s debate over affirmative action policies. As Harlan put it, quote, "The law regards man as man and takes no account of the surroundings of his color when his civil rights, as guaranteed by the supreme law of the land, are involved." So Harlan like Douglass, is basically saying that it is evident, or it's self-evident, that if you have a right for one person, you have to have a right for everyone. Again, civil rights is a government must-do list. If our objective is equality under the law, if that's our objective, then you cannot separate based on race. You cannot separate based on religion. You cannot separate people based on how they were born. On page 116, essay number 24, Justice Harlan dissenting. In respect of civil rights common to all citizens, the Constitution of the United States does not, I think, permit any public authority to know the race of those entitled to be protected in their enjoyment of such rights. There is not a Bill of Rights for different races. There's not a Bill of Rights for different religions. There's not a different Bill of Rights for different genders. There's not a different Bill of Rights on basis of sexual orientation. Everyone has the same rights, or no one has the rights. Every true man has a pride of race, and under appropriate circumstances, when the rights of others, his equals before the law, are not affected, it is his privilege to express such pride and to take such action based upon it as to him seems proper. What's the kicker there? Right? If you want to express your pride of race, no matter what your race is, it's permissible to do so when the rights of others, your equals under the law, are not affected. But I deny that any legislative body or judicial tribunal may have regard to the race of citizens when the civil rights of those citizens are involved. Indeed, such legislation as that here in question is inconsistent not only with that equality of rights which pertains to citizenship, national and state, but with personal liberty enjoyed by everyone within the United States. It was said in argument that the statute of Louisiana does not discriminate against either race, but prescribes a rule applicable alike to white and colored citizens. This argument does not meet the difficulty, right? This argument doesn't meet the smell test. Everyone knows that the statute in question had its origin in the purpose not so much to exclude white persons from railroad cars occupied by blacks as to exclude colored people from the coaches occupied or assigned to white persons. It is one thing for a railroad carrier to furnish or to be required by law to furnish equal accommodations for all whom they are under their legal duty to carry. It is quite another thing for the government to forbid citizens of the white and black races from traveling in the same public conveyance, and to punish officers of railroad companies for permitting persons of the two races to occupy the same passenger coach. If a state can prescribe as a rule of civil conduct that whites and blacks shall not travel as passengers in the same railroad coach, why may it not so regulate that the use of streets of its cities and towns as to compel white citizens to keep one side of the street and black citizens to keep to the other? Why may it not upon like grounds punish whites and blacks who ride together in a streetcar or in open vehicles on a public road or street? Why may it not require sheriffs to assign whites to one side of a courtroom and blacks to another? And why may it not also prohibit commingling of the two races in the galleries of legislative halls or in the assemblages convened for the consideration of the political questions of the day? Further, if this statute of Louisiana is consistent with the personal liberty of citizens, why may not the state require the separation in railroad coaches of native and naturalized citizens of the United States, or Protestants and Roman Catholics? The answer given in the argument to these questions was that the regulations of the kind they suggest would be unreasonable and could not therefore stand before the law. Is it meant that the determination of the question of legislative power depends upon the inquiry whether the statute, whose validity is questioned, is, in the judgment of the courts, a reasonable one, taking all of the circumstances into consideration? A statute may be unreasonable merely because sound public policy forbade its enactment. But I do not understand that the courts have anything to do with the policy or expediency of legislation. It is not the court's role to make sure that public policy or legislation goes smoothly. It's the court's role to interpret the Constitution and to protect the civil liberties of everyone from encroachment by the state. He goes on, remember, Harlan was a slaveholder. The white race deems itself to be the dominant race in this country, and so it is in prestige, in achievements, in education, in wealth, and in power. So I doubt not it will continue to be for all time, if it remains true to its great heritage and holds fast to the principles of constitutional liberty. But in view of the Constitution, in the eye of the law, there is in this country no superior, dominant ruling class of citizens. This is why I stress this idea of equality under the law. Because even a slaveholder like Harlan, even a slaveholder, a man who fought for the Confederacy, or at least was involved with the Confederacy, a person who is elected on a white supremacist ticket in Kentucky, but he reforms. And he sees and realizes the brutality of slavery. And he sees and realizes that this idea of race is too much in the consciousness of his fellow Confederates, of his fellow Southerners. And that once you take this road, right, once you take this road under law, right, under the law, all people have liberty and rights, or no one does. Right? Or no one does. One cannot be free in a country that enslaves its people. One cannot be free if the state and the institutions are discriminating on the basis of one of the protected classes. And Harlan understands this. And Harlan, again, expresses this in a very, very powerful dissent. Now, what are we talking about? Right? So there are two types of segregation. There is de jure, which means by law, and then there's de facto, which means as a matter of fact. So in the South, we have segregation, the Jim Crow laws, we call them, right? We have these laws that forbade the mixing of facilities between whites and blacks, and this is what the legal sanction of Plessy v. Ferguson gives these states, this idea to institutionalize segregation. And in the civil rights movement of Dr. King and Malcolm X and others in the 1960s, 50s, and 60s, primarily was designed to get rid and change these laws in the South. In the North and in the West, we tend to have de facto segregation, where there is, in neighborhoods like in Chicago or in neighborhoods in Los Angeles, we have basically segregation based on some type of economic factors or some kind of geographic factors in which communities are located by different neighborhoods. De jure segregation is much easier to get rid of when you're talking about the law than de facto. And the whole controversy later after the civil rights movement in the 1970s to 1980s, the whole controversy changes to integration of schools, changes to the integration of neighborhoods, and the integration of housing, which was much more violent in the North and in the West, and probably one could say a larger failure than the civil rights movement of the South. And today, one could contend that race relations in the South are probably more ahead than the race relations in the West or in the North. But again, Harlan sees that the Constitution says there is no caste here. There is no ruling class. Now, of course, from a Marxist perspective, that's That's not true because a Marxist looks at economics. But Harlan is looking through the law, and Harlan is looking through the Constitution because that's his position, that is his role, to interpret the Constitution for us. And he says, our Constitution is colorblind and neither knows nor tolerates classes among its citizens. In respect to the civil rights, all citizens are equal before the law. The humblest is the peer of the most powerful. The law regards man as man and takes no account of his surroundings or of his color when his civil rights are guaranteed by the supreme law of the land are involved. It is therefore to be regretted that this high tribunal, the final expositor of the fundamental law of the land, has reached the conclusion that it is competent for a state to regulate the enjoyment by its citizens of their civil rights solely upon the basis of race. It's a shame no one listened to him, isn't it? It's a shame that no one listened to Harlan. In my opinion, the judgment this day rendered will in time prove to be quite as pernicious as the decision made by this tribunal in the Dred Scott case. The Dred Scott case is this famous case that basically brought up the Civil War. Dred Scott was an escaped slave, and he was brought back, and he said he was a free man, therefore you couldn't bring him back. The Supreme Court ruled basically that there was no such thing as free soil. And that's one of the reasons why we had the Civil War. These two decisions, Dred Scott and Plessy, are probably the two worst decisions the Supreme Court ever made. And we see in the summer of 2020, we see some of the results of these cases. The present decision, it may well be apprehended, will not only stimulate aggressions, more or less brutal and irritating, upon the admitted rights of colored citizens, but will encourage the belief that it is possible, by means of state enactments, to defeat the benefits, purposes of the people of the United States had in view when they adopted the recent amendments of the Constitution, by one which the blacks of this country were made citizens of the United States and the states in which they respectively reside, and whose privileges and immunities as citizens the states are forbidden to abridge. 60 million of whites are in no danger from the presence here of 8 billion blacks. The destinies of the two races in this country are indissolubly linked together, and the interests of both require that the common government of all shall not permit the seeds of race hate to be planted under the sanction of law. What can more certainly arouse race hate? What more certainly creates and perpetuates a feeling of distrust between these races than the state enactments, which in fact proceeded on the grounds that colored citizens are so inferior and degraded that they cannot be allowed to sit in public coaches occupied by white citizens? That, as all will admit, is the real meaning of the such legislation as was enacted in Louisiana. I am of the opinion that the statute of Louisiana is inconsistent with the personal liberties of citizens, white and black, and that state and hostile to both the spirit and the letter of the Constitution of the United States. If laws of like character should be enacted in the several states of the Union, the effect would be in the highest degree mischievous. Slavery as an institution tolerated by law would, it is true, have disappeared from our country, but there would remain a power in the states by sinister legislation to interfere with the full enjoyment of the blessings of freedom to regulate civil rights, common to all citizens, upon the basis of race, and to place in a condition of legal inferiority a large body of American citizens now constituting a part of the political community called the people of the United States, for whom and by whom, through representatives of our government, is administered. Such a system is inconsistent with the guarantee given by the Constitution to each state of a republican form of government, and may be stricken down by the congressional action or by the courts in the discharge of their solemn duty to maintain the supreme law of the land, anything in the Constitution or laws of any state to contrary notwithstanding. For the reasons stated, I am constrained to withhold my assent from the opinion. And again, if you look at the dates of these, Plessy v. Ferguson is 1896, and Brown v. Board of Education that worked on desegregating the schools is 1954. So again, when we compare Harlan's dissent to Douglas and Marshall's speeches, it's ironic that the slaveholder actually has less hope and actually sees the issues and sees this mischievous, right, this really bad opinion, because he understands what's going to happen. You're going to get a slew of legislation that's going to start dividing everybody by race. And once you do that, the consciousness of the races becomes more prominent. And we see that today with different groups. The famous feuds between the Irish and the Italians in Boston. Do people look at that anymore as being important? The famous rivalries and the famous religious differences between Protestants and Catholics. Do people look at that as being very important? No. Why? Because there was not the law that kept on reinforcing this difference, as Harlan predicted. There's not the law that keeps on saying, oh, you are this and that, you're that. And that's the problem. That's the problems that we face. This is the legacy that we face today. Is that, again, Thurgood Marshall says, the law segregated us, and we are in the process of creating an avenue in which the law will desegregate us, and we will strive for equality under the law. That's where we are. So again, the difference between civil liberties and civil rights. Civil liberties are a government cannot do. It is a protection the individuals have, right? The individual is protected. It's a shield, right? The individual is protected from state action. Harlan and civil rights are a sword in which the individual is guaranteed equality under the law. Now, what happens when people no longer respect the rule of law? People look at the protection of private property and say it's unimportant. People look at violations, petty and mundane violations of the law, and it's not important. That's a corrosive agent, right? On, again, the second pillar of our nation, rule of law. So we have a total breakdown of the constitutional system in 1860 called the Civil War. And then we have the institutions sort of failing because of Plessy v. Ferguson. Except what? Except you have Harlan planting the seeds for Brown v. Board of Education. You have Harlan saying you cannot base things on race. You cannot segregate, and you cannot, right? You cannot have state action that interferes with the individual's protected civil liberties. And one of those civil liberties is the right to assemble. One of those civil liberties is the right to travel and to express yourself. And so, again, the solutions that we seek, the seeds have been planted. The institutions that we have are not perfect. And if you're using perfection as a criteria, of course, any institution will fail. But the Constitution and the amendment process, especially the 13th, 14th, and 15th Amendment, we're talking about getting out of that Civil War. When we talk about the expansion of what Thurgood Marshall said, the expansion of the perception of what does it mean when we talk about we the people? What we mean is everyone over 18. And what we also mean is everyone below 18. What we're talking about is people, right? Every person, even if you are an undocumented person in this country, you are protected by the civil liberties that are produced in the Constitution. We don't even divide, in our system, we don't divide people who are here legally or people who are here illegally. And so, because we have failed in teaching the law, teaching the Constitution to people, right? People don't really understand what the avenues of political power, where can they get resolution to these issues? And that's where we are today. So again, we have this distinction between civil liberties and civil rights. Frederick Douglass had hope. Thurgood Marshall had hope. Justice Harlan, he's a little more sanguine, isn't he? Because he's seen it. And he has seen what this idea of racial identification or racial supremacy brings us, or brings the community that practices it. Death and destruction. All right, his South, Harlan's Kentucky, was neutral in the Civil War, but he saw that quote unquote way of life end. And it's ironic, again, when Harlan died, Frederick Douglass went to his funeral. And the First AME Church in New York City had a huge funeral for him. Because, again, those leaders understood what he was saying. Those leaders understood the importance of what this dissent is. And it was later on in the 1950s and 60s that Dr. King and Thurgood Marshall and Malcolm X and all the other civil rights leaders used the law as a means, as that sword for equality. Thank you for joining me. We'll see you next time.